Hi there, my name is Jon Hummel, and I'm with the National Foundation for Gun Rights. And today, what we're going to talk about is something that was just released by the Supreme Court. What this is this is the reply from the Second Circuit as to why they are seemingly going against the Supreme Court's decision in Bruen with them putting a stay on injunction that was placed on New York's recently passed gun laws. So we're going to look at three main points and the three big takeaways that we have from this document. First, the Second Circuit came forth and said that this court is not likely to grant review of the forthcoming decision from the Court of Appeals. What that means is that the Second Circuit is saying to the Supreme Court, you guys are not likely to grant certiorari or cert on this case because it's still too new. Their argument is that, Bruen was released just half a year ago, and the lower courts are still grappling with and trying to figure out how to apply this appropriately. Interestingly is, in this part of their argument, they say, we don't even think that this new law necessarily implicates the Second Amendment. So why on earth would you, the Supreme Court that deals with constitutional issues, ever need to bring it up? The problem with that is that in one of their opening paragraphs, they state that this law was written in response to the Bruen decision. Because the Supreme Court struck down Bruen, New York came forth and came up with new gun restrictions and laws to restrict the Second Amendment. Basically, they tip their hand that this is not a good argument in their opening statements. But it's still something that they wanted to bring forward because they don't want to admit that what they're doing absolutely violates Bruen. The second main takeaway from this document is where the Second Circuit says that applicants have not shown that the Court of Appeals clearly and demonstrably erred in granting a stay. Throughout this whole section of the document, the Second Circuit basically comes forth with all of its different arguments as to why they were not incorrect, I should say, why they didn't err in their ruling, and them saying that this law is still fine and should not be struck down. They go through a bunch of different factors, saying that this is now the status quo, which is interesting because the law has only been in effect 3 months, which is not, in my opinion, enough time to really create a status quo. They go through all the different aspects of it, from the licensing requirements, where they changed the permitting scheme to be a good moral character, and they go through all the different reasons why that is totally different than a proper cause, even though it is way more invasive and takes way more research and effort on the part of the individual applying for the permit. Throughout this section, they try to use historical analogs, which is something that Bruen did lay out, saying that you need to look at the text, history, and tradition in order to justify any law that would infringe the Second Amendment. And throughout this, they come up with some very, very far-fetched stretches. One of the best is with the portion of the law that is sometimes considered the vampire law, the restricted locations, where you cannot bring a firearm into a location unless there's a sign or some demonstrable invitation for you to exercise your Second Amendment rights there. It's called a vampire law because vampires in mythology are only allowed to enter a premises once invited. Essentially what this does is it says you cannot have rights unless someone else says that you can exercise those rights. To justify that, they used the historical analog that had to deal with poaching, where farmers would not allow people to hunt on their lands, and they said, see, they're denying people firearms. Totally different, but again, the Second Circuit is going to use as many stretches and reach as far as they can to make sure they can justify what they're doing here. But yeah, all of it is just one giant reach to try and justify what they're doing with this case. The third point that I think is very important for us to mention in this video is that the Second Circuit comes forth and says that applicants will not suffer irreparable injury from the stay. This is just not true. if these laws violate the New Yorkers' Second Amendment rights, their constitutional rights, that in and of itself is harm and is something that needs to be addressed. So that point right there is so easily refuted. Whenever your constitutional rights are violated, that is in and of itself a harm and needs to be addressed as such. One of the final points as we end this video that I do want to say is that near the very end of this document, the Second Circuit points the finger right at the Supreme Court in a pretty interesting way. One of their last lines is that they say this court, meaning the Supreme Court, this court's premature intervention is neither appropriate nor necessary. Basically what they're saying to the Supreme Court is, you guys don't need to get involved. You need to stay out and let us figure this out. Which is very interesting because this is something that the Supreme Court required of them, asked them to supply this document, and it's pretty bold to point a finger right back at the Supreme Court and say, you guys need to stay out of our business. So we will see what happens with this going forward. Again, this is just their response. We don't know how the Supreme Court will take this, what they're going to do with it, but we're going to be looking for that and monitoring that to let you know as soon as we find out something of that nature. Hey, thank you so much for spending your time with us in this video. We would love for you to get more involved with this by clicking the link in the description below. As always, we would love for you to like, comment, and subscribe just to get the word more out there about what we're doing to help restore your constitutional rights. Again, my name is Jon Hummel, and we'll see you next time.